Hi, I'm Chuck Chvala, former Senate Majority Leader,
And I'm Scott Jensen, former Assembly Speaker.
and we're the insiders. So, Scott, the Wisconsin Supreme Court took a whack at the governor on his budget vetoes and also expressed an opinion about the lame duck session laws. What's your take?
I thought that the court landed in the right spot and that their effort was really one to make sure that the legislative branch and the executive branch were on equal footing. With regards to the budget vetoes, I think it's a pretty sensible decision that says that the governor cannot completely transform a law in a completely different one than what the legislative intent was. And the good example that was in that case is that the legislature had passed a program to replace old school buses, and the governor turned it into a program to provide electric charging stations for private cars, something completely different. And he's not the first governor to do that. Since Tommy Thompson, I think every administration has had a governor who's cleverly used his veto to completely rewrite the law that the legislature had from one subject to a different subject. And now the court is saying, wait, it has to be reasonably fundamentally similar to what the legislature passed. You can change things, but you can't turn it into something completely different than the legislature ever even considered. So I think that was right. And I think they also got it right in what would be a more nonpartisan decision with regards to the lame duck laws. Part of that decision was completely unanimous. Part of it was 5-2, and another part was 4-3, where two liberals and two conservatives got together to write the majority decision there. And essentially what they're saying is, again, a balancing of the powers between the executive and the legislative branch. They're saying the attorney general can't just spend the settlement winnings on whatever he wants to say on it, that the legislature is the body that appropriates, and they need to review the plan that the attorney general has put together for how to spend that money. And they've also said that there are limits as to how far executive agencies can go in writing rules beyond what the legislature had considered, but that when they're providing guidance about how those rules will be interpreted, that still is up to the executive branch. So I thought they did a good job of trying to put the legislature and the executive branch on equal footing.
Well, it's interesting here. Scott's going to sound more like the lawyer, and me as the lawyer is going to sound more like the political person. I think your former boss, Tommy Thompson, who had a huge veto pen or pencil sitting in the corner of his office, would have, if he were here in the 90s, would have said, oh, no, the Supreme Court can't do that. The veto power was restricted by referendum after the legislature adopted potential constitutional amendments to scale it back. But what remained should be available to the governor. And Governor Evers used it within those parameters, and it should not have been outlawed. What both this decision and the lame duck laws decisions really had in common is that it was a partisan Supreme Court, a very partisan Wisconsin Supreme Court, acting to limit the governor, and at the same time then giving a power to the Republicans in the legislature. Now, Scott does cite the one decision that was a bipartisan decision, but I think overall, that is the import of what's going on here. We've gotten to the point where the court really looks at results and then figures out a legal theory to get them to where they are. And I think it's not working well. I do have to say that I think when we get a bipartisan decision, and that's what it is, even though Scott calls it liberal and conservative, it's really Democrats and Republicans. And where we have that, I'm encouraged by that. But I think overall it's a disappointing development. But that wasn't the only legal thing that happened. And I know it's maybe take a little more time here, Scott, but there were some very important decisions from the federal appellate court with regard to voting rights in Wisconsin. What's your take on that?
Yeah, I thought the court got it right there. Essentially, they agreed with the legislature that when it comes to things like early voting in Wisconsin, that everyone should have the same access to early voting. And previously in Wisconsin, larger cities like Milwaukee and Madison would have early voting 6 and 7 weeks before the election. They're able to staff that even on Saturdays so people could come in and vote. You can't do that. What you can do in Milwaukee and Madison, you can't do in Markesan and Quantico. They have much smaller governments. They don't have the ability to staff that for that long. And so the legislature passed a law saying that We'll have it statewide for the 2 weeks before the election. It'll be the same everywhere. I think that's fair. The court said that that was acceptable. And though they did point out that they thought there was a partisan advantage to Republicans on that, they said they're allowed to, that the law on its substance was fair and equal across the board. So I thought that made sense. The slight changes to the voter ID requirements made sense. So I think the court got it right.
And the court absolutely got it wrong. Diane, is it Woods, who's Charlie Sykes' former wife, is on the appellate court, was one of Sykes, I'm sorry, was one of the people who was Diane Sykes, who was one of the former, one of the people who has a close relationship or former close relationship. It was, again, in my view, a very partisan decision. And what it is this is the one that really gives me a problem. And I have a hard time finding any sympathy with someone who says this is fair. Clearly what happens in rural areas is you have a small number of people. They go in and vote and they wait maybe 5 minutes, if that, and they're done. The reason cities need more is because they have thousands of people at voting places. How can you look at this and say that giving people more opportunity to vote is wrong when you see lines of even a mile sometimes, but certainly all the way out through parking lots at voting places in urban areas? That you never see that line in a rural voting place. Why? Because the town only has 500 voters. They don't need that time. It is absolutely voter suppression. There is no two ways around it. And it is disturbing to me to hear anyone, especially a federal court, appellate court judge, to make an argument which is clearly about voter suppression and actually is racist. It's at its core racist when it's voter suppression, as it will be in Milwaukee this fall. That is terribly wrong. And to even hear the argument made for it, I cannot tell you how much that disturbs me, that argument can be made in the United States in 2020, especially after what's happened with George Floyd and everything subsequent to it.
Well, it was
and make no mistake, it is racist.
A three-judge panel. It was a unanimous decision by a three-judge panel, judges who have been on that court for decades in some cases. So the other thing to remember here in Wisconsin is we found out in the spring, right, that people are willing to switch to absentee balloting, and that actually goes earlier. It's the same all over the state. Everyone has the same access at the same time. And I think this cycle, a lot of people who might have early voted in places like Madison and Milwaukee in the past will do so now by absentee balloting because they tried it. It worked out fine in the vast majority of cases. So I think everyone should have the same access to an absentee ballot and to early voting at the same time all over the state, and that's what the federal court came down on.
Scott, what the court did say, the one thing that you could say in defense of the court is the court would say, we have to find a constitutional reason to not allow this to happen. Right. But what they did say is there's a huge partisan advantage. And that's the problem. This is a partisan and a racist advantage which the Republican legislature decided to take advantage of. It's wrong. It's just dead wrong. It's voter suppression. When you have to win by keeping other people in the democracy from voting, there is something seriously wrong with what your party is doing. And I cannot tell you, I mean, there's nothing more fundamental than the right to vote. And what this does is inhibit the right to vote for people. And when we see those lines blocks long this November, we will not see every person who drove by that line and said, it's not worth it. My vote won't make a difference. That is wrong. And I cannot tell you how disappointed I am that the court could not find a legal way to get around it. But what they did comment on was partisan advantage, which means, guess what? Black people don't get to vote.
Well, we'll see what the impact is this November. I'm betting that's going to be an extraordinary turnout by both sides in November in Wisconsin.
We'll see you next time.